tell the truth and shame the devil.
All right. Good afternoon, everybody. We coming here live, uncut, unedited. We got two beautiful ladies, and they're going to school us, take us to school, educate us. And before we get started, I'd like you guys to share this video. We will not be taking any phone calls. So if you have any questions, make sure you put them in a messenger. And I promise you, I'll try to read them and get to them. So this is live, and we're talking about the fair housing. Is it fair housing?
Fair housing and the Just Housing Amendment.
All right. So if you got a felony or something, we want to talk to you. We want to give you some good information. Mm-hmm. But before we get started, ladies, introduce yourselves.
I'm Lysandra Hutchinson. I'm one of the outreach and training coordinators at the Cook County Commission on Human Rights.
And I am Aja Sumter. I am also one of the outreach and training coordinators for the Cook County Commission on Human Rights. Thank you for having us.
All right, no problem. So let's get into the meat of it right away. We're not going to waste no time. And I'm going to use myself as an example. Okay. Say that I'm a felon, which I'm not, but I'm just saying.
Yeah.
And I'm on probation. I got my life back on track. I'm been working for the past year. Credit is okay, decent enough. So, and I want an apartment. Yeah. So tell me what I can do, what I can't, what's the rules, what the landlord property manager can do. So help me out.
Absolutely. So great thing is there is a ordinance in Cook County that protects those individuals like yourself in this scenario from being discriminated against based on covered criminal history. So that means that they cannot be denied outright or even asked at the initial stage of the screening process about a criminal conviction or arrest or conviction record at all. That's now been prohibited. So if you qualify, you apply for a unit and you qualify based on income, based on credit history, then at that point, there should be no asking about a background check. Once that's called pre-qualification. Once you pre-qualify, then you move on to a second step, which could include a background check. Okay. It doesn't have to. The landlord does not have to conduct a background check, but if they want to, they can do that. But the Just Housing Amendment prohibits them from looking beyond the past 3 years. Mm-hmm. So they can't go back 4, 5, 6, 7, 10, 9 years.
Okay.
Within the 3 years, if they find a conviction, then they're required to do what's called an individualized assessment. So it basically gives the person, the applicant, an opportunity to talk about their context. What was the severity and the nature of the conviction? How old were they? Was it connected to a disability? Mm-hmm. Has there been some proof of rehabilitation since that happened? For example, they have good tenant history ever since that happened. How many convictions happened within the past 3 years? So they're able to take into account a lot of different factors, and then based on that, they can either deny or approve the applicant.
I have a question.
Yes.
Y'all know I'm a little slow. So if it's 3 years and older,
they cannot be considered.
Okay. With the exception now, what if a person is locked up for pedophilia?
That's the exception.
So, right. That's one. Put it out there.
The one
that's not midnight people. I just want to.
Yeah. No. Thank you for asking that. That's a great question. Yeah, that is an exception. Obviously, if the person is a sex offender, if they're on the sex offender list, obviously that is an exception to the JHA, the Just Housing Amendment. But anything else is covered.
Because you have some of the property owners. I'm talking about a private. You meet with a man. Well, before we get started, if you got a criminal record, right, I'm not gonna rent to it. They do that. Right. On a slick side. You're like, we don't. They'll do that.
Right.
And not knowing they probably do aware of the ordinances going on, but
I think it depends. It depends on the context. So the Just Housing Amendment has been in place since 2019. It was voted on in 2019 and approved back then, and then it began enforcement in 2020. Mm-hmm. So this has been around at this point. We're going on 6 years in April. And I think it is a common thought that, okay, because this is the law everywhere in Cook County, because it applies in the Cook County suburbs as well as the city of Chicago, that people automatically know about it. And by and large, what we're seeing and what we've heard through conversation and being out in communities with people is that small landlords, those people who have like 2 to 6 units, largely are not aware that the Just Housing Amendment is in place. Whereas these larger, multi-unit, these large property management companies are very aware. Sometimes they may comply, sometimes they may not, but a lot of small unit landlords are still very much trying to be aware of what the fair housing laws are, especially as it pertains to protections for individuals with arrest and conviction history.
Now, if my memory serves me well, now the first process when you go, we just say I'm going to a private land, one of the small ones. The first thing they should be, I should credit check. Is it that first? The criminal should be last, right?
Exactly.
Okay.
So if the first step should not include a criminal background check at all.
Okay.
And I want to interject here too, because you had said even if you like go on a tour and the landlord or the housing provider is like, oh, just to let you know ahead of time, I don't accept felons, people with backgrounds, whatever language they use. That is a direct violation of this protection. So they shouldn't even be asking you the question until they've pre-qualified your application.
It shouldn't be asked verbally, and it shouldn't be
included in the application.
At all. Not in the first step.
I got another great question for you guys. Like, man, suppose that I have a young person, 16 or 17, that's a felon. I'm an adult. I'm clean. Because most landlords ask if you have a son or daughter over 17 or 15, they want to write a check on too. Now, how that works?
That's a great question. And we've received that question before. And I would have to follow up with leadership to see like what the nature is, because of course, it would be applicable to any household member, I believe. But we largely look at that from the perspective of adult household members, as it relates to people, who are technically minors, but who may have a background. We would need to follow up on that.
Right. Definitely. I do believe juvenile records should not be considered.
Yeah.
So,
yeah.
That was a good question, wasn't it?
Yeah, it was a great question.
Because, a lot of these private owners, they're afraid of teenagers.
Yeah. But with the sex offender piece, that definitely applies.
Okay.
So if you're not the sex offender, but someone in your household is, then you definitely have a right to deny. It's not covered under the JJ.
So as a sex offender person, where can they move to? I mean, it just...
That's true.
That's the challenge.
That's a big challenge.
And we can't speak to that, to be honest, because of the fact that it is an explicit exception underneath the ordinance. But I don't know about you, Lysandra. I know for myself, I've received that question in several contexts, and it's difficult to navigate. It definitely is.
Now, what about I'm just y'all forgive me, but gun registry, because you have some guys that is on the gun registry. So how that works?
So the registry piece, from what I have been privy to just in different conversations, is that people still kind of, at least, and I want to be clear, this is based on like hearsay and just conversations, that people still run checks based off of an individual's placement on particular registries, and we're still very much trying to navigate how do we maintain compliance with JHA, the Just Housing Amendment, while acknowledging that these other registries exist. Maybe not necessarily in the context of sex crimes, but in the context of other acts, and whether or not that should still be a basis for denying someone's housing application.
These are great questions, man. I'm sorry. I didn't have a list of questions. I'm just trying to think in the mind of our audience that's listening. Some people won't come out. It may be them. It may be them. I'm thinking, anything else, you guys? I
do want to note that in terms of, there are a lot of, especially small landlords, that we here still don't know about the housing amendment, and that's a part of what we do at the commission. We go out, we train, we go out to outreach events. We conduct meetings with small landlords, just trying to get the word out, making sure that people are aware of the ordinance, and basically how we enforce it. We want them to be aware, and then we also provide tools for them so that they can make sure that they comply with the ordinance.
I got another question. Y'all know my mind is right.
I know it is.
Now, I've heard this happen. When you go for a credit check, and a background check. They try to do it at the same time.
Yeah.
Mm-hmm.
So what's up with that? So they like say like one may be $25 and the other may be $30. Well, just give me money over for
Mm-hmm.
So how that works now? I'm asking you guys.
Yeah. So it basically the responsibility rests on the landlord to make sure that they comply and that a background check or a credit history check and the background check are separate, that they're not happening at the same time.
But see, they have you pay for them at the same.
Right, and that's on the landlord to not do that.
Right.
To not accept payment or ask for payment that would basically happen simultaneously. And then there also are third-party screening companies sometimes that they add their basically the tool has them together. So we have worked with like TransUnion, for example, to make sure that they are in compliance with the Just Housing Amendment, making sure that landlords can come or request a background check after the initial credit history is pulled. So yeah, that's also work to be done also.
Yeah. And I want to piggyback off of what LaSandra said, because a lot of times, again, there are housing providers and landlords and property managers who don't have that awareness of what the law is. And so they may just be doing processes that, streamline their screening application process. Like, oh, I don't want to have to go through all of this extra work, extra steps to, sort of screen potential tenants. So let me outsource it and find a company to do it for me. But the issue is, like LaSandra said, if they are using a third-party screening tool, which they are more than more than able to do, we're not trying to restrict anybody's ability to use their preferred company or their preferred product. They have to be aware that they have to separate those checks, because in the event that you're running both checks at the same time and you use, that background check that was premature, essentially, and let's say you have a prospective tenant who knows the law and is very aware of their protections and they want to file a complaint, you would still be held liable at the commission as a result of that.
Now, what's the penalty for a landlord that violates this ordinance?
The penalties are a case-by-case basis.
Okay.
So, and that's how it is with all of our investigative processes. But it can look like different things. So, I'm going to kind of talk about this in two different ways.
Okay.
If, two parties are at the investigative step and maybe they don't want to move forward with like going to administrative hearing, we do send them to mediation, which is essentially like an opportunity for them to sit down and come to an agreement that they both, have worked on, that doesn't require all the additional steps and potentially additional cost of going through like an actual court proceeding. So they may come to agreement privately. That can look like different things. That could be, paying a particular agreed upon amount in order to cover damages and, emotional distress, whatever is discussed. Or that could be the restoration of a housing application. But oftentimes in those mediations, the result may not be disclosed to the commission. They don't have to tell the commission what that result is, as long as the two parties have come to an agreement and are satisfied with that agreement. Separately, let's say that they do go through the entire investigative process where it has to go before an administrative hearing judge, and then the commission issues the final decision. Those awards or those fines or whatever the case is can be the same. It can be a longer process. It could be a more expensive process depending on who the parties are. But like I said, it can be, the restoration of a housing application. It could be making that housing available. It could be, again, paying fines and damages, covering lawyer fees, monetary damages. So it just depends on what's agreed upon at the end of the investigation.
Now, during that process, suppose that private landlord, property owner, rent the house out, rent the apartment out, even though they're going through litigation with the person that. So, should the place be on hold from not to rent?
That's a great question.
Right.
Ooh, I'm putting fire on the place. I'm sorry.
Good question.
Y'all know I was totally blind to what was going on, so I'm sorry.
But you prepared. You want it.
Yeah.
You want it.
Go ahead.
So I was about to say, I don't know if you want to take it, you want me to take it.
Okay.
So and this actually gets to a piece that I wanted to mention earlier.
Okay.
So before accepting any application fee, in order to run a background check or whatever the landlord requires as part of their application process, the landlord is required to supply 3 things to every applicant. A notice of the tenant selection screening criteria, which just shows how your application is going to be reviewed. Tenant selection criteria, a copy of Part 700 of the Commission's procedural rules. Part 700 speaks specifically to the Just Housing Amendment, so like essentially how the Commission governs and enforces the ordinance. And then they have the right to dispute any inaccuracies related to the criminal background check step. And in that right to dispute the criminal background check step, they also have to supply them with the address, email address, and phone number of the Cook County Commission, just in case they want to file a complaint with us. So that has to be supplied before anybody's asking for any sort of monetary exchange, any sort of payment. As it relates to, and remind me what this, because I'm
not gonna get you guys in trouble.
No.
Okay.
As it relates to, you were asking about holding the unit. Right. So nothing in the Commission's procedural rules, so that Part 700 that I was mentioning, nothing in the procedural rules says that a unit has to be held while the individual is going through like a screening process or a dispute process. So if the housing provider has another pre-qualified applicant that is eligible for that unit, they would be able to rent that unit out. But that also doesn't have any impact on what's happening in the investigative process.
Okay.
Yeah. It gets deep.
It is.
I will note too, also, once they receive, if they were denied, the applicant has a 5-day window to dispute any inaccuracies in the background check. So they have to do it within a certain time frame as well.
But in that 5 days, to piggyback off of that, there is nothing in the procedural rules that says that the landlord has to hold the unit.
Okay, that's what was one of my main concerns.
Yeah,
I'm just thinking like if someone out there that's listening, because
that's a good question.
Yeah, because it's a lot of discrimination going on. Okay, that's anything else, ladies?
So one thing that Lysandra mentioned that I think we really want to amplify.
Okay, that's
when it comes to working in commissions like ours, I think sometimes there's a misconception or a misunderstanding that like we're only representing one side or the other. When in actuality, we're trying to help everybody. We're trying to make sure that everybody that's involved in like fair housing or impacted by fair housing has the resources and the tools that they need in order to feel supported, to know their rights, and to know their responsibilities to comply with these laws. And so one thing that Lysandra, you mentioned earlier, was wanting to make sure that we supply resources to landlords to know what their responsibilities are under the Just Housing Amendment. And so we have a ton of resources on our website, but one thing that we really want to highlight is the screening process notice template for housing providers. So in that 3-step process that Lysandra mentioned about the pre-qualification, the second step of the criminal background check step, and the third step about either the approval or the denial, we've essentially created a template for landlords to use to inform applicants of where they are in their housing application process. And I like to think of it as working in 2 ways. It's providing that direct support to landlords and housing providers just so that they know, is my process in compliance with this fair housing law? And it also provides some clarity to applicants who want to know, what step they are in the application screening process and where they're going next. So, just want to raise that to just really highlight we're here to try to provide everybody, whether they're a housing provider or they're looking for housing, with the resources that they need in order to do that effectively.
Oh, my brain is running again. I got a hopping here. Gender. So you guys have, some people may be transgender, and you have some property owners, they're like,
Yeah, so the Cook County Commission on Human Rights enforces the Cook County Human Rights Ordinance, and that protects against discrimination based on gender, sexual orientation, basically anything: sex, race,
Religion.
religion,
ancestry,
national
origin,
yeah.
So people should not be discriminated. They should not, and the key words are like should not be. Obviously, we know that discrimination is still happening. But if an individual is being discriminated against based off of their gender identity or any of the other protections under our ordinance, we're here to enforce that that's not correct and that there are consequences to participating in such negative behavior.
If I have a problem, how can I get in contact with you guys? I mean, who would I ask for? What number? Give us a number.
That's a great question.
Yeah.
So first of all, we like to give the website, so anyone can go to cookcountyil.gov.
Matter of fact, I'm gonna have you type it in.
Okay. They can go to cookcountyil.gov and then just search for Commission on Human Rights or search for Just Housing Amendment if it's Just Housing Amendment question, and you can find all of our contact information there. And then also,
I'm gonna be all in business today.
I mean, the good thing is, as Lassandra's typing it in, is the fact that we want y'all to know. Right. We want y'all to ask questions because we're here to serve the community. We're here to serve the residents of Cook County. So as Lysandra said, cookcountyil.gov, it's the official Cook County government website. There's that search bar in the middle of the screen. If you type in the Just Housing Amendment or the Cook County Commission on Human Rights, it'll take you to the first page on that screen, and it'll have all of our contact information. We're located downtown at 69 West Washington on the 11th floor. I've been to that building. Yeah. And our phone number for Cook County commission complaints or even just questions is 312-603-1100. We also have an email, human.rights@cookcountyil.gov. And I think Lysandra handled this perfectly. We always refer folks to the website because you may not remember what I said, but the information is there. Accessible.
Now, another question I'm going to ask. Do you guys come out to different non-for-profit organizations and, trainings and stuff like that? Because a lot of people need to know that.
Absolutely. So we provide free training. I'll give you that email as well, just in case anybody wants to request training.
Okay.
We come out and provide free training in the community. We talk about basically the human rights ordinance, so all of those protected classes, and how we protect against discrimination or harassment. But also we talk about the JSHA. We have fair housing trainings that we provide as well. So please feel free to contact us, and I can also add this email to the chat. So it's dhreoutreach.training@cookcountyil.gov.
Yeah, you know what you're doing down there.
And we're a team of three. The outreach team is a team of three.
Okay.
Lysandra and I, and then our other colleague, Bianca. But literally anytime folks want us to come out to talk about fair housing, we also have worker protection trainings because we also enforce worker protection ordinances for Cook County. We're happy to coordinate with people and see what works best for them. And I mean, I would be remiss to not mention Teamwork Englewood and to shout you out for providing us this space. You all have been great partners over the past several years. And so I think even this opportunity is evidence of the fact that we're more than willing to meet people where they are and to provide them these free resources because they're free. Why wouldn't you want to?
So I want to say this too. You did say it earlier. You're not just one side. You're for both sides. So I like that. I like that. You know.
And I mean, even with the Just Housing Amendment pages that Lysandra mentioned on our website, we have a page specific for landlords, which includes FAQs, templates, process notices, screening notices, things like that, and obviously links to the ordinance and to our rules. And we do the exact same thing for housing seekers. We call them housing seekers, but us, like, you know, applicants and potential tenants. So like everybody has opportunity to have free resources that they can pick through, ask questions, get their questions answered, and learn more.
All right, people, y'all need to ask some questions. I'm asking them all for you guys. I'm trying to, you know, I'm doing it. Because I know how that screening process, what you call them, housing seekers.
Housing seekers.
Okay, yeah.
And that, you know, that's a blanket term. Like because especially with like the Just Housing Amendment, we oftentimes talk about it in the context of like people who are looking for rental housing. But the cool thing about the Just Housing Amendment, JHA, is that it applies to all kinds of housing. So it doesn't matter if it's a house or if it's an apartment or if it's a townhouse, if it's a condo. It doesn't matter if it's a small unit. It doesn't matter if it's multiple units. Like this is applicable as what we say is like it has no size specifications. So, you know, you could be a buyer and potentially have to deal with, you know, discrimination based on your arrest or conviction history. And that's covered under the Just Housing Amendment. But you can also be a renter and deal with that.
Oh, you know, I got another question. It's coming to my oh my God. A person that rent and the owner go ahead and rent to them, they come and find out their background don't check out so well. So they got to go through the legal process of
So they find out later after they've rented to them.
Right.
They've done,
Or let me ask this two-part question. If they commit a crime while living on the property but not convicted, you know, you have any rules to that? You guys know anything? That's a good question. You know, some people they felons, they just haven't got caught, but they, you know, just.
Well, I would say to the first question.
Okay.
If they did not run a background check, let's say initially, and they rent to the person, and later they find out that they have had a conviction within the past 3 years, they can go through the process at that point, which would be to conduct the individualized assessment. So that would be the same process where they're basically asking a series of questions to learn more about the severity and nature of the conviction, again, or how many convictions happened within the past 3 years, and then they're free to make a determination based on that information.
But the thing is, they're in the apartment already.
Yeah, they're in the apartment.
So they're going to have to go through the eviction process.
And I mean,
that's I know I'm asking you guys these tough questions,
because that gets
that could be
yeah. And I had a thought, but I think I just lost it. But yeah, they are able to undergo the individualized assessment piece. And one thing, actually, here's my thoughts coming back to me. One thing that I want to mention about the individualized assessment, of course, is to provide that context surrounding the individual's background that may have been recovered. And Lysandra made a really good point earlier about like you don't have to do step 2, but a lot of people, of course, choose to run the background check step, right? So in the event that they do, that individualized assessment is really trying to see, okay, does the individual pose a potential risk or threat to, they call it, it's demonstrable risk to personal safety or property. So, and essentially what that means is by bringing this person into the community, or by this person already living in the community, in your scenario, are they posing a risk to my safety, their safety, the safety of other people around them, or to the risk of the property itself. So I think that's something to keep in mind when conducting the individualized assessment. And it's just a questionnaire to just understand more.
Ooh, ladies, man,
you hitting us with these questions.
I'm on fire today. I remember when I first started, I was timid, but I guess my skills are getting better and better to get more confident with you guys. And you know, I'm trying to think of something else Because it's hard when people have felonies. It's hard.
Yeah.
I mean, even myself, I would want to know who's living in my property, whether I was a real estate agency or what. What about, how do you guys, this may be out of you guys' league, let me just reword this. If a tenant moves in, I mean, they pass all the credit, the criminal check, and they commit a crime on a property.
That gets out of our wheelhouse. That is out of our wheelhouse.
Okay, we'll leave that.
Because, like you said, one thing that we make clear when we're doing these is that, one, we don't provide legal advice.
Right.
We are a neutral fact-finding organization. So we can only go based off of what is presented to us in the context of a complaint and an investigation. All of that, that gets into, housing court, that's not necessarily tenant rights. Yeah. That's outside of our realm. However, we, because of the extensive community network that we have with nonprofits and governmental organizations and non-governmental organizations, we're happy to refer housing, specifically in this case, housing providers, so it'd be like landlords, realtors, property management companies, to legal resources to see what that could potentially look like.
Right.
So one that I want to highlight just for the context of this conversation is Cook County Legal Aid for Housing and Debt. They provide free legal resources to, again, everybody. It could be individuals in the housing, like looking for housing. It could be individuals who need legal representation. But it also could be a place for landlords who need that advice to receive that advice about how to proceed with an eviction proceeding and everything like that. But I think one thing that I would say just in this context is, if something happens on the property, we don't handle that. That is something that, hopefully you got somebody on retainer that can answer that question.
And I was going to say about that to the question too, Martin, if they have a tenant that's already in the unit and then they do a background check and later find out that they've had a conviction within the past few years, they can do the individualized assessment, but there also may be some tenants' rights issues. So they would, I agree, would need to seek out some legal counsel to figure out what the law says about those tenant rights at that point. So yeah.
No.
And then one thing I want to piggyback off that too is because, we're speaking in hypotheticals, we're speaking in generalities. If the housing provider chooses to go toward the route of, I don't know how I feel about this person living in this unit, et cetera, and they start finding ways to harass them, then that is where we would step in.
Okay.
So they have the right, and we want to affirm that they have the right, like if they run the background checks that the unit is already occupied and they find something, they have the right to run the individualized assessment, proceed however they choose from there. But if they're making the tenant uncomfortable or they're finding ways to discriminate against them after learning this information, that is a potential grounds for complaint with us.
Okay, man, that's deep. It's a lot going on out here in the city of Chicago, Cook County.
And I mean, I think one thing that we've been saying this whole time is like, there's a lot that people don't know. But the thing that we always emphasize is like, we're here. And we have nothing but time and capacity to answer people's questions. Matter of fact, we just did a training with Community Investment Corporation on Friday, and they specifically do property management training. So we're getting in front of housing providers, whether that's someone who already owns a building, somebody who's thinking about owning some property. We get in front of folks and let them know, like, hey, this is what you have available at your disposal. And I kid you not, every time I get in front of one of these spaces with a housing provider, some of them are just shocked. They're like, what do you mean? And I have questions about this and I have questions about that, because they simply don't know.
And I think too, I just want to piggyback on that too, if there are questions, again, feel free to call the office. So we answer questions. People, if they feel that they've been discriminated against, an individual can make an appointment to speak to an investigator, come in person, or have a phone call with the investigator, give their specific situation, lay that out so that the investigator can advise them on how to move forward.
Perfect. I think I'm out of questions, but I mean, anything else?
Last piece, and now we just piggybacking off of one.
Okay, all right.
But yes, please schedule an intake appointment with any of our investigators. We have some really amazing investigators who they've got so much experience investigating fair housing and other forms of discrimination in Cook County. But our complaint process is free. On the website that Lysandra provided earlier, there is a big button that says file a complaint with the commission. So in the event that you don't, we strongly encourage you, let me be clear, we strongly encourage people to do the intake appointment first, to speak with the investigator, say this is what happened to me. But after that takes place, if you want to go ahead and hit that button that says file a complaint with the commission, we certainly encourage you to do so, and that will be reviewed and assigned out as needed.
No more questions.
So you thought you were tapped out?
I thought I was tapped out. So how long does the process?
Oh, that's
that's tricky. That can be tricky. You can be like, well, we'll be back in office 3 weeks from now, you know. Maybe you guys can help me.
So,
just give estimate time. You know, it's not a...
Yeah. So, typically what happens is as soon as the complaint is received, because our online complaints are automated so that they receive notification that a new complaint has been filed. Senior leadership, so our director or our deputy director will then assign that out to one of the investigators. We've heard a couple of things from the investigators. They usually say
don't throw them under the bus.
No. And again, I want to be. If any of y'all are listening, I hope that this does not come off the wrong way. But they try to get those assigned out as soon as possible.
Okay.
And I will say the investigative process can take up to 6 months. It does not have to take that whole time, but they get a window of 180 days to investigate, come up with a determination, etc. Sometimes it could take less based on the facts of the case. Sometimes it could take more. If it exceeds that 180-day limit, then they go before our commission, who then votes on whether or not the extension on the investigation will be granted. But it can be a lengthy process from the time that you submit the complaint application, it will submit the complaint form, up until like actually initiating the investigative process and actually hearing what the determination or the result of the investigation is. So we always try to lead with that to let people know, like, you have this right, but also be mindful of like all the time that it can take.
Final question. How did you guys, what is the history of the ordinance come out? Who came up with this? Did you guys do a study or what? I mean, was it a bunch of complaints or
just housing amendments?
Yeah, that's what I'm talking about.
Yeah, I mean, a lot of folks got together, people in the community, people who were justice impacted individuals, attorneys, and basically just saw how much really housing is an anchor for people that are coming out of prison. They have, they're given, a small amount of money and just now go out here and make it happen. And there's such a higher rate or likelihood of recidivism when this person is unhoused and they're discriminated against just blanketly because they have a conviction or arrest record. So people just saw the dire need, like housing is a human right, it's a basic need. And so a lot of people fought to make sure that this ordinance was passed in 2019 by the Board of Commissioners in Cook County. So it was just like a collective effort of people who saw the issue and wanted to do something about it.
Now, I want you guys to clarify something. This is basically something we talked about already. Now, if you have a conviction that's not 3 years old, can they not rent to you, or is up to the landlord or property manager?
So to reopen that, if we're at step 2 now, we want to be clear. Like you already passed that one, we at step 2. If the housing provider, the landlord runs the background check and they find anything within the 3 years from the date of application, that would then, create the necessity to do the individualized assessment. Anything older than that 3 years should not be used as a basis for denying the application. It shouldn't even be a consideration if it's older than 3 years. So what's today's date? Today is March 16th, 2026. Yeah. Anything, let's say you're applying for a housing on this date. Anything that the housing provider reviews would only need to be within the window of March 16th, 2023 up until March 16th, 2026. So if they're looking at anything from 2020, 2022, 2021, 1998, it should not be a consideration for the housing application.
Just want to get that clear.
Yeah, that's a good question.
Yeah.
I'm done. I'm done, ladies. I'm done. You guys convinced me. I just had to put y'all power.
You made us work today.
Yeah,
I did. Yeah. I'm sorry, but I'm just trying to put in my mind the audience.
Absolutely.
Because some people they don't know how to talk. They don't know how to express themselves. So I'm their voice.
Yeah.
I'm their voice. So hey. All right, I'm done.
Yeah, thank you.
Well, this ends our program. I want to thank you guys for coming out. I want to thank Teamwork Inglewood, Mark Mitchell, using me as always, a navigator. So, man, it was people. Make sure you guys share the video, like the video, go to the different websites and find out if you've been discriminated against. There is some help for you, especially those what you call justice impacted. I love that word. I love that. I love it.
Impacted individuals.
Yeah, right. I love that. So again, we want to thank you guys. That's it for today. All right, you already know what it is.
You already know what it is.
Live, uncut,
unedited.
Tell the truth.
Tell the truth.
And what?
And shame the devil.
Most of all,
I love being black.